Hey folks, welcome. We're going to take a minute for people to join. Hey folks, welcome. So if you've come for a jury nullification training, you're in the right place. And we can go ahead and ask you if you're already here, if you want to share your name in the chat and a time, you can start doing that now, and a time that you stood up for somebody else. We'd love to see that. And of course, you can tell us where you're coming from if you want. And we are not recording tonight, just so you know. There is a recording of other folks giving this training if you want to have access to a recording later. Welcome, welcome. I see I stand up for patients at my clinic every day. That's great. So maybe Tech, could we go ahead and put up the hello prompt on slide 3 for folks as they're joining?
Sorry, just give me one sec while I do
Sure.
that.
So the prompt for folks is share your name and one time you stood up for someone else, but we'll also get that on the screen for you where you can see it in a second. Thank you. So I'm seeing, I stand up for patients, I stand up for neighbors, stood up for a friend in an abusive relationship, delivering food for people who are afraid to go out. Lots here. Stood up for a student, a child protective services worker needing to place a granddaughter with undocumented relatives. Minneapolis police during one of their homeless camp evictions. Standing up for students unfairly dismissed from college. Lots of standing up for our neighbors. Doing ice watch outside the neighborhood school. Thank you for all this standing up for the unhoused. This is great. So I want to recognize that standing up for other people is part of what we're talking about tonight in this jury nullification training. If we can go on to the next slide, I want to make sure to first of all say, my name's Marla. I am not a lawyer, and therefore I cannot give you legal advice. None of this is legal advice. This is education about how one part of the criminal legal system works. And so it's not legal advice, not a lawyer. The other important note here is that if you are currently on a jury, this presentation isn't for you. It's been ruled in more than one court that talking to jurors about active jurors about any kind of education about the rights of jurors is not okay, and we don't want to mess with any ongoing trials. If you have been summoned to serve on a jury but not gone to jury selection yet, you are not currently on a jury. If you're currently on a jury, that means you've been assigned, you've gone through jury selection. So if that's you, you've gone through jury selection, you were put on a jury, come do this training later after the trial that you're serving on is over. Yeah, we don't want to interfere with active court proceedings. All right, let's go on to the next slide. All right, as you can see, we're jumping right in. Let's do a scenario that's based on a true story. So you might remember this guy, the sandwich guy. So it's Washington, D.C., and the city's been occupied by the National Guard, and federal agents are approached by somebody shouting, "Fuck you, fucking fascist, why are you here? I don't want you in my city," and then throws a sandwich. Next slide. There you go. So let's imagine you've been put on his grand jury. So not all crimes need grand juries, but for the ones that do, they're a step that is meant to require a jury of your peers to say there is probable cause that a crime happened here before that case could move to a trial. And so if the jury finds there's enough evidence to move to a criminal trial, that's an indictment. And we're going to practice using our independent judgment as if we were on a grand jury. So let's go to the next slide. All right, so this first part is a real quote from the prosecutor in this real case. "You are in this grand jury to review evidence presented by us to decide whether there is enough reason to formally charge someone with a serious crime." So that's actually true of every grand jury. "We all may have views about the federal law enforcement presence in DC. That's not what this case is about." And then the prosecutor says something about how you'll see there's no defense.
Court documents and video.
We're going to try that again. Folks on the tech side, do we need plan B? Let's see what I can do.
No, sorry, we should be good. I just froze
Okay.
for a sec. Sorry.
Yeah. So we're going, we now should be on the video.
Court documents and video show what prosecutors say happened Sunday night near 14th and U Street. They allege Dunn verbally confronted federal officers, then threw his Subway sandwich at one of them at close range.
In retrospect, he's going to say, hey, why did I do that? But at the time, mentally, he's like, hey, this is my city. Don't want you here.
Police arrested Dunn, and according to court records, he admitted, quote, "I did it. I threw the sandwich."
It's tragic.
He appeared in D.C. Superior Court Monday where a judge released him. But on Wednesday, federal prosecutors issued a new arrest warrant charging him with felony assault in federal court. Now, inside the courtroom, Dunn's attorney said he tried to turn himself in, but received no response from the DOJ. She claims 20 officers later came to his home to arrest him. The attorney also revealed Dunn served in the U.S. Air Force, which was a fact prosecutors didn't appear to know, and that he had been working for the DOJ.
Okay. So we can go on to the next slide. There we go. So you saw the video, right? He clearly, on the evidence would suggest that he attacked an officer by throwing a sandwich. He ran and then admitted to it sort of on the scene. Oh, right. This is a real quote. You can't go around throwing stuff at people when you're mad. You can't do it to your neighbor, and you can't do it to law enforcement. And then the prosecutor is saying this is an aggravated assault, not merely a misdemeanor, but a felony for assaulting, resisting, and impeding an officer under Title 18 of the United States Code. So, so they're trying to get an indictment on a felony charge for what you just saw in the video. Let's go ahead to the next slide. The prosecutor says to indict, but you don't feel good about it. Let's have you all put in the chat how you might vote against indictment anyway. What might you do? Some reasons you might oppose. And I guess I should check if the chat is still turned on for everybody. Oh yeah, it is. Great. There's a lot of questions about whether there was any harm and if a sandwich can really harm anybody. Is this really assault? Is this really a felony? It's not a serious crime. It was an act of kinetic speech. I appreciate this framing. Comical, not criminal. Yep, nobody was injured. I see lots of not a felony. That officer wasn't impeded, clearly. All right, so let's go to the next slide. All right, many possible reasons. You all ran through a lot of them. One of them was the law that was broken just and justly applied in this case. Seems like we're pretty clear as a group that whatever standard there is for assault, that it probably, like felony assault, it probably wasn't reached in this case where somebody was hit with a Subway sandwich. One of them is the law that was broken constitutional, that was allegedly broken. Probably this law is constitutional, but maybe not justly applied. Do other factors exist that would make strict enforcement of the law unjust? This is always a good question. Was anybody harmed? Maybe he thought they were hungry. Okay, would the punishment fit the crime? Right, so sometimes we have statutes where even if the state can prove its case beyond a reasonable doubt, the penalty that exists for that action is just wildly out of line with the alleged crime, which is probably another way to say that it wouldn't be a just application of the law. And then there's you just aren't persuaded. All right, let's go to the next slide. Okay, so you vote to not indict. Many grand juries don't need unanimous decisions. They only need a majority of jurors to vote yes. And so maybe you're close to getting a majority in your situation. Then the prosecutors make you stay late. They pressure everybody to indict. They threaten the jurors. Legally dubious strategies. So what happens next? Let's go on to the next slide.
And here's the kicker. Today we learned that federal prosecutors were not able to convince a grand jury to charge him with a felony. A group of his peers simply refused to buy the government's ginned up case. And to be clear, in normal times, it is extraordinarily rare for a grand jury to refuse to approve an indictment. The deck is heavily stacked towards the prosecutors in these situations. There's the old cliche, right? You could get a grand jury to indict a ham sandwich. And yet, the U.S. Attorney's Office for D.C. could not get a grand jury to indict a guy for throwing the sandwich. This isn't an isolated incident. Earlier this week, we learned that same U.S. Attorney, Jeanine Pirro, last seen on Fox's The Five, that her office similarly failed to get a felony indictment against a woman who's alleged to have tried to block ICE from detaining someone. Not one, not two, but 3 grand juries refused to sign off on felony charges in that case. Eventually, Pirro just gave up, charged her with a misdemeanor instead. These are just some of the latest examples of grand juries, even prosecutors themselves, judges refusing to go along with Donald Trump's weaponization of the Department of Justice.
All right. So that's what we call jury nullification, folks. There would be no way to claim that the sandwich wasn't thrown, right? But this jury, which means, the prosecutors may have proved the technical elements of the case, but the jury said, no way. Like, we're not giving you an indictment on this. And so that is one way that we as regular folks can insert ourselves into the criminal legal system and create some justice through some non-cooperation. Let's go on to the next slide. All right, so here's the sort of flow chart of things. Prosecutors presented evidence to a grand jury and they were seeking felony charges. The grand jury said no to indictment. And in a rare move, then prosecutors filed a lesser misdemeanor charge, which didn't require a grand jury in order to go to trial. And the case goes before a criminal jury. One thing I'll say about this is there are a few places I've recently learned in Tennessee to go to criminal trial, even on a misdemeanor. A grand jury needs to say, yes, there's probable cause here to charge this person and to take them to trial. But in most places, it's only felony charges that require an indictment from a grand jury to go ahead to trial. All right, let's go ahead to the next. All right, so let's say that you've been put on his criminal jury for the misdemeanor charge that they went ahead and filed. A criminal jury those are the ones like on the TV shows that determine guilt or innocence. And then, except for in a few states, a criminal jury does actually require a unanimous agreement by jurors to convict. And so in those places, even one person refusing to go along with everybody else's verdict can do what's called hanging the jury. So a hung jury means there's no conviction. I'm seeing a request to not move the mouse around as much because it's distracting. And I'm sure we can accomplish that. So even in states where a unanimous verdict is required from the jury, a unanimous vote on the verdict is required, one person can cause a hung jury. A hung jury doesn't mean an acquittal. It doesn't mean not guilty. It does mean that this trial is over. And the prosecutor would then have to decide if they wanted to go through the effort of taking this case to jury trial again with a new jury. So they can start over, but it's a lot of work. And I've been part of supporting somebody in a case where a prosecutor did try the case again, and they still only got, after jury nullification, and they still only got a conviction on one of 2 counts with the second jury. All right, let's go on to the next slide. All right, so we're in this criminal trial for a misdemeanor. Here's your real quote from the prosecutor. "This is not a case about someone with strong opinions. It's about an individual who crossed the line." You'll hear the aggrieved officer smelling the onions and the mustard. You just cannot have people going around attacking federal officials. So that's what the prosecutor says. What happens next? And the defense says a foot long from Subway could not and certainly did not inflict any bodily harm. Throwing a sandwich is not a forcible offense. This whole case is vindictive and selective prosecution. They're targeting him because of his speech, not because of actual harm. That whole thing was a real quote. All right, next. All right, so now again, you face the question, how might you vote against this conviction? So we're asking here to sharpen how you might articulate a not guilty verdict, given the options you heard last time. What would you say? Because let's say that you're trying to convince the people, the other jurors, like just through, the jurors have to deliberate on the evidence. Like, what would you be saying in the jury room about what you feel is the right answer? See that in the chat. And while people are answering, I'll say that I see this question about which grand juries can operate only under a majority. I don't know. This would be an easy thing for you to find out in your jurisdiction. With a little search, you could even probably call the clerk of the courts where you are and ask the question. All right, what do we got here? Onions and mustard is not harm. No one was harmed. Yeah, I see a lot of no harm. Well, we are in a misdemeanor, so punishment with a felony doesn't fit the action of throwing a sandwich, but maybe a misdemeanor. Maybe it doesn't also match a misdemeanor. Yeah, I see assault would require an intent to injure. And clearly he was using sandwich as a prop for his speech. Yeah, lots of good stuff here. The selective prosecution feels interesting. The only harm was to the law enforcement officer's ego. Not premeditated. So waste of our time and government resources. See some good puns in here. All right, let's go on to the next slide. All right, so the jury does acquit him. And so that means, I think in DC, that unanimously they acquitted him of a misdemeanor charge. Let's go on to the next slide. So that's jury nullification. And this, of course, is a high-profile case, and one reason to choose it is because you've all probably heard about it, and so know a little bit more of the context about it. And there were news clips for us to play about it. But the same case, if it hadn't been high-profile, might have been sent by a grand jury in other times. We don't know. But because people are paying attention in this moment in ways that maybe they haven't been to how the criminal legal system works, this is our opportunity to spread some information about jury nullification being what I heard one judge say once in New Hampshire is the historic prerogative of the jury to be the conscience of the community. And there is a long history of jury nullification in the US. So let's go ahead to the next slide. All right, so we're going to think about how jury nullification has worked over time. Next slide. All right, so there are many examples of early American juries nullifying British customs and trade laws. So you can see here there's an example in 1735 of an acquittal of a printer charged with seditious libel for criticizing the colonial governor. He definitely printed the material, and the jury refused to convict. And this is an early way of establishing press freedom and showing that jurors could defy unjust laws. Let's go to the next. Northern juries also undermined the Fugitive Slave Act. So in 1851, a jury in Syracuse acquitted the rescuer of an escaped person who had been enslaved, had been caught by probably people searching for him. This person had forcibly freed him from federal marshals. And the jury in New York said, nope, we're not convicting him for this. And so this led to a situation in which juries across the North, or in states across the North, this law was kind of unenforceable. Let's go ahead. Likewise, during the civil rights movement, we saw jury nullification, but it actually cut both ways. So in a use of jury nullification that I think none of us feel great about, Emmett Till's murder trial, an all-white jury acquitted the folks accused of that murder. But at the same time, activist juries nullified against segregation laws and protest arrests. So in Albany, Georgia in 1962, in Jackson, Mississippi in 1963. I don't know if Albany was a lunch counter sit-in, but the one in Jackson was a lunch counter sit-in. Jurors refused to convict civil rights demonstrators for disturbing the peace. Let's go ahead. And then anti-Vietnam War activists sometimes benefited from sympathetic juries. So in one trial with a number of co-defendants, a Boston jury acquitted Dr. Benjamin Spock and some co-defendants of counseling draft evasion. There were some people in the same trial that were convicted. And the mixed acquittal verdicts reflected the divisions in the community about moral resistance to the war. But they were an expression of, the conscience of the community. Go ahead. And we have a lot of examples in the Trump era. So there was an LA protester charged for assaulting a Border Patrol agent, and a federal jury acquitted him in under an hour. The sandwich guy we've already talked about, they refused to indict him on a felony charge and then also nullified at his misdemeanor trial. And then this says many jury cases tried by the Trump Department of Justice have been rejected. I don't know what the other examples of that are, so I'm not gonna tell you any of them. All right, next slide. All right, how else could jury nullification be used in these times? So if you could put in the chat, write sometimes in places where you could imagine jury nullification being a useful expression of the conscience of the community. I see prosecuting legal observers. Anyone protesting at the Whipple building in Minneapolis. Yeah, if you're selected for a trial for somebody who is charged with harboring an undocumented person, recording ICE, impeding ICE, protecting protesters in general. Yep, protecting reporters who are present covering events. If you think the law or the application of it directly contradicts the Constitution. Domestic violence, self-defense. Yeah, anybody who's been charged in a selective way just because they oppose Trump. Yeah, great. Protecting a minor. Protecting anyone under the new Antifa regulations, which are not laws. They're like executive orders. Protecting immigrant neighbors. Great. Yeah, being called the domestic terrorist for blowing a whistle. There's currently not a federal domestic terrorism statute that you can be charged under, but there is a domestic terrorism sentencing enhancement. But some states do have domestic terrorism statutes that people can be charged with directly, as we know. All right, let's go to the next slide. All right, is jury nullification legal? Let's get into it. Oh, and I'm going to start using this word lawful. I didn't change it in the slides. I said I was going to, and then I didn't. I want to tell you why I want to use the word lawful. A couple of reasons. When we are speaking quickly, and people can't read what's on a screen and they only hear us, it's a lot harder to mishear the word lawful and unlawful versus legal and illegal. It might be a little bit harder to hear the difference. We are also in this context where people are called, like human beings are called illegal by some people, and that's just gross. And so I have taken to talking about things being lawful and unlawful. They mean the exact same thing. Okay, so jurors cannot be lawfully punished for their verdicts, which means a court cannot punish you for your verdict, no matter what reason you had. The court doesn't need to know what reason you had. It's your right to return a verdict. Whatever verdict you return, a judge cannot direct a jury to deliver a guilty verdict. That doesn't mean that prosecutors or judges won't discourage you from using your conscience. They might imply or lie, even in the instructions to the jury. The jury instructions generally say, if you find that the state has proved the elements of this case beyond a reasonable doubt, then you must convict. That's not true, and that's what the jury instructions almost always say. There are a few places where if you argue about it hard enough, the judge might give an instruction that says, you may convict. If the state has proved the case beyond a reasonable doubt, you may convict. This is a distinction without a difference, I think, to most jurors hearing may and must. And they might tell you that you can't use your own judgment about this. It doesn't violate your oath as a juror, and it is historically your right. And let's hear what Supreme Court Justice Sonia Sotomayor has to say about it.
A difference. I finished an article yesterday that Professor Charles Wolfram wrote in 1972 on the history of the Seventh Amendment that said the people who were responsible for insisting that the Seventh Amendment be part of the Bill of Rights, and by the way, he attributes the whole existence of the Bill of Rights to the concern with jury trials, and that it wasn't in the Constitution. They didn't put it in the original Constitution. It was promised as a quid pro quo for ratification that we will have a Bill of Rights that guarantees civil jury trials. That those people wanted jury trials not because they would get the same result as a judge, but because they would get a different result than the judge. And they wanted it in spite of the fact that jury trials would be longer, more expensive, maybe less predictable. So I had forgotten that. I was really never focused on that as being the reason for, if we just went back to the reason for the Seventh Amendment, you know, that maybe that's the answer to why America.
You know, the Second Circuit has an opinion that basically says that juries should never be instructed about jury nullification, and that any instruction that would suggest it is wrong. I hewed very closely to the Second Circuit line for many, many years. As I've grown more in the system and watching it, I'm not so sure that that's right. Think about what juries did during the Civil Rights Movement. If it weren't for jury nullification, we would have many civil rights individuals who would be convicted felons or otherwise for things that today we think are protected by the First Amendment. There is a place, I think, for jury nullification, finding the balance of that and the role that a judge should or should not play in advising juries about that is, I think, a different thing. But I think that you're right. Our forefathers did not believe that juries necessarily always got it right, but it was, I think, what they believed is that the jury getting
You're muted, Marla.
Thank you. We're going to move on now to talk about uh, jury nullification and how you do it. Um, before we, it's okay to stay on this slide. Before we do, I want to sort of re-emphasize what we just heard. You know, at the founding of this country, when the court systems were beginning to be laid out and the role of a jury was sort of institutionalized, it was there as a protection of the people, um, just in case the system needed to be checked by somebody else, being the people, even though it was going to be sort of cumbersome and expensive. And I once got dismissed from a jury because, well, a prosecutor was trying to get me dismissed because he had figured out I was an activist. But a judge asked me if I believed in the courts, and I said, Your Honor, I think that when juries are allowed to hear all of the relevant information, that the courts are the most democratic, you know, that a jury trial is the most democratic mode of government that we have remaining to us. And the defense attorney, like, was laughing so hard that he snorted through his nose. And I just kind of looked at him like, bro, I'm on your side. And so the judge dismissed me for cause, which we'll talk about what that means in a minute. Let's go ahead and talk about how to do jury nullification. All right, so if you've never gotten one of these, you might get, the way that you get on a jury is that you get a summons in the mail. You're not going to get that if you don't have your address information up to date with your local government officials. We'll talk about that a little bit more in a minute. You respond to the summons, which means you go when you're supposed to. You sit through jury selection, which we'll talk about in detail in a second. You get picked on a jury. You sit through the trial. You pay attention. You deliberate in the jury room with conscience once the judge has handed over the case to the jury, and don't get removed. All right, let's go on to the next slide. All right, so the summons that you'll get in the mail, those go to adult U.S. citizens who are in the system. So, you know, if your address is up to date on your driver's license, that's probably the way. If you have a driver's license or other government ID, that's the way this gets to you. Respond immediately and honestly to the summons about jury qualification. So some places, everybody has some sort of questionnaire that you have to fill out. This just provides information to both the defense and the prosecution when they're doing jury selection about like who was in the room. A lot of times you might know that if there's any injury involved, notoriously nurses and other medical professionals don't end up on a jury because the prosecutor or the defense, depending on who's injured, doesn't want people who have independent knowledge about, you know, how bodies work to be on a jury. Although sometimes, you know, they can't get enough people struck from the jury who have specialized knowledge. But you need to answer all those questions truthfully. Let's go to the next slide. All right, so jury selection is called voir dire. We're gonna hear a very good video in a minute about what that is, where the person, the only problem with the video I have is the pronunciation of these words, voir dire, which is great. It's jury selection. We can just call it that. That's when the judge and attorneys question potential jurors. So that's the jury pool, everybody who's been summoned to jury selection, to see if they can be fair and impartial. And each side can ask the court to remove certain jurors, anybody they choose, for cause, if they seem biased. If the judge agrees, like, yeah, this isn't a good juror for this case, the judge can agree that they can be removed for cause. Each side will also have a limited number of peremptory strikes, which means you don't have to have any good reason. You just have to say, I'm going to use one of my peremptory strikes to remove this juror if the judge will not remove them for cause at the request of the lawyer. When I was removed from jury during selection, like from the jury pool, the prosecutor was trying really hard to not have to use a peremptory strike on me. And that's why I got extra questions. All right, next slide.
Did you know that there is an interview process for serving on a jury? Depending on how this interview goes, the attorneys on the case can kick you off the jury for any reason they want. Well, any reason short of discrimination. This interview is conducted on the record, meaning that you are first placed under oath before your interview and all of your answers are transcribed by the court reporter. This interview is known as voir dire, but you might know it as jury selection. What you might not realize though, is that picking a jury is more about deselection rather than selection. The sole purpose of voir dire is to determine the suitability of potential jurors to hear a particular case. The ultimate goal is to assemble a jury that can objectively weigh the evidence and render a fair verdict without bias or prejudice. During voir dire, the attorneys are simply trying to determine which jurors need to be kicked off the panel. Jurors can be removed with a challenge for cause or as a result of a peremptory challenge. Challenges for cause are legal motions where the attorney believes that the juror is actually prejudiced against the client or has expressed a bias that would prevent them from being fair and impartial. Peremptory challenges are a tool employed during jury selection that allows attorneys to excuse a potential juror without ever providing a specific reason. Unlike challenges for cause, which require a demonstrated bias or legal disqualification, peremptory challenges are exercised at the discretion of the attorney, provided that they do not violate certain constitutional principles. The number of peremptory challenges varies greatly from trial to trial. Before we go any further, do you actually know how jury selection works? Let's demonstrate with an example. The question everyone has is, what are the chances of me actually getting picked for jury duty? Imagine if you and 19 of your friends stood in line to ride the last Ferris wheel ride of the day. This is a tiny Ferris wheel that only carries 12 people, and when it's full, the carnival closes for the day. You're number 20 in line, so it doesn't seem like you have a very good chance of riding the Ferris wheel, does it? Not so fast. The Ferris wheel operator starts asking all 20 of you questions about your experiences with Ferris wheels. One person in line states that he actually hates Ferris wheels. One person in line states that she has a history of vandalizing Ferris wheels. And then another person in line states that he has debilitating motion sickness. Before the Ferris wheel operator started asking questions, the first 12 people in line would be getting on the ride. But after these answers, these 3 people are kicked out of line for cause. Now, of the people left in line, original numbers 1 through 15 are guaranteed to ride since they are now the first 12 people in line. But wait, now the Ferris wheel operator gets to kick 5 people out of line without having to give any explanation why. The peremptory challenge. He kicks 5 people out of line. That means you are now in the first 12 people in line and you just found yourself on the Ferris wheel. That's exactly how jury selection works. The first 12 jurors who are not kicked off will serve on the jury. As a potential juror, it is essential for you to approach the jury selection process with an understanding of peremptory challenges and the reasons behind their use. Here are some key points to consider. Jurors often have limited information about the case during voir dire. Attorneys may use peremptory challenges based on general impressions, body language, or other subtle cues that may not be apparent to jurors. It is important for you to recognize that these challenges do not necessarily reflect on your character or qualifications. Attorneys may employ peremptory challenges as part of their trial strategy. The selection of a jury is a dynamic process, influenced by the unique aspects of each case. Certain individuals may be excluded not because of any personal inadequacy, but because of how their presence might impact the dynamics of the trial. If you appear to be a natural leader and have given answers that seem like you might be sympathetic to the other side, then the attorney likely wouldn't take a chance by leaving you on the jury, as it's just safer to use a peremptory challenge. It might not be anything that you say or do during jury selection that causes the attorney to use a peremptory challenge to remove you from the jury. Sometimes it is as simple as where you work or your education history. If you work for a government agency, then you could be viewed as sympathetic to the state during a criminal prosecution. If you have a graduate degree in a scientific field, and the case has a medical or scientific aspect, then you could be viewed as someone who might try to apply their own experience rather than applying the admitted evidence. While peremptory challenges are a valuable tool for attorneys, their use is not without limitation. The Supreme Court has established that the exercise of peremptory challenges based on race or gender violates the Equal Protection Clause of the 14th Amendment. These days, such protection would also likely apply to attempts to use peremptory challenges on the basis of race, creed, religion, national origin, or even sexual orientation. If an attorney suspects that the opposing party is using peremptory challenges in a discriminatory manner, they can raise a Batson challenge, prompting the court to evaluate the legitimacy of the challenges. When attorneys ask questions during voir dire, it is essential to answer truthfully and candidly. The goal is to provide a complete and accurate picture of your background, experiences, and potential biases. Honest communication is crucial in forming a jury that can fairly assess the case. Remember, you'll be placed under oath to tell the truth before you even start answering questions. Because of that, it is extremely difficult to avoid a proper peremptory challenge without committing perjury. When you're asked questions about your experience and your answers reveal that you might be biased, well, there's nothing wrong with that. It doesn't mean that you wouldn't make a good juror. It just means that you might not make the best juror for this particular case. At the same time, if you're trying to get out of jury duty, you shouldn't answer untruthfully in an effort to get removed. I've heard people plan to say some pretty outrageous things in order to be excused from jury service. The real secret to getting out of jury duty is to just speak up and answer questions. The less you say, the less reason the attorneys will have to remove you. The more you participate, the more likely the attorneys will uncover some form of bias. The most important thing is for you to have respect for the legal process. One day, you might find yourself in need of a fair and impartial jury.
All right. So again, some reasons you might not get selected to a jury is if you admit to bias. And in particular, saying that you wouldn't convict under a law you disagree with. You may feel that that's probably true, but if you could truthfully say that you're going to wait to hear the evidence, then that would be better if you wanted to be on the jury, but only if it was truthful. Failure to follow instructions. So you have to agree when the judge instructs you to apply the law as given. You have to agree to do that. You have to agree in the room that you would do that. Challenge for cause. So either side can ask the judge to remove you for cause if you show unwillingness to apply the law impartially. And then there's the peremptory strike that we just heard about. Even without cause, both sides have a limited number of peremptory challenges to exclude somebody for any reason except for, on the basis of race, gender, and some of the other categories we heard about. This says they definitely will if you talk about jury nullification. I think that probably a judge would strike you for cause if you talked about jury nullification. So the short version of this is you can legally nullify once you're on a jury, but if you say that's your plan, and probably even if you say that's your plan in the jury room when you're deliberating, you'll likely be removed. And then later it would be a problem if you said that that was your plan. Next slide. All right, so some tips for being selected, if that's what you want. Dress in neutral clothes and monitor your body language. So just try to seem as neutral as possible. Some of us have very expressive faces, and you might have to fix your face or practice doing it in your responses to what you're hearing. Consider how you can answer questions both truthfully and neutrally. So the example given here is you might be asked how you feel about police officers, or say your brother's wrongful arrest. And you can be like, no, I'm going to listen to evidence based on what's presented and not how I feel about cops based on my brother's case. If you keep your answers brief and provide the minimum of information, there is less to go on for the attorneys doing the jury selection. Don't mention jury nullification or any jury education you've received, and don't seem eager. Now, if you get asked directly, they would have to have a reason to ask you directly. But if you've received education about jurors' rights, if you were asked directly, you probably shouldn't lie about that. Um, uh, and then emphasize that you cannot commit to a particular outcome before you've seen the case. The other thing I will say that's not in here. So let's say you're not selected or like it's clear to you that you're about to be removed from the process. It might be worth thinking about going ahead and talking about jury nullification. Don't use the words jury nullification because nobody knows what that means, but talking about how you understand that it is the right of jurors to use their conscience in decisions about what the right verdict would be if you already believe that you're about to be removed. Or saying it on the way out of the room if you're walking. That's not legal advice. It's a thing I wish I had done on the way out of the room. All right, next slide. For the questions that are coming up in the chat, I think it would be so great if you would put them in the Q&A feature. So we're going to deal with questions that come into the Q&A feature a little bit later. We're not going to stop midstream here to do that. All right, so say you've been selected to a jury, then we want to make sure that you deliberate with conscience. So you get to decide which testimony you believe, how confident you are in those conclusions, and whether that confidence is enough for conviction. You are never obligated to vote a particular way, and if you hear nothing else tonight, I want you to hear this. You don't have to justify or explain your vote. Even if the judge disagrees with it or can't believe that you said not guilty as a jury, you will never be required to justify why, as a jury, you voted that way. The reason I want to tell you this is I have experience at a trial where it turns out the 6 jurors, this was a trial in Washington State, really wanted to acquit the defendants. It was a protest case. But they believed that because the state had proved the case, the elements of the case beyond a reasonable doubt, that they would have to justify why they made this call. And they felt that they came up with a reason why they could say they didn't believe that the state met those elements on one count and not the other. So they convicted on trespassing. And we know this because when the judge released the jurors and told them they could talk to anybody they wanted, they didn't have to talk to anybody. They came out to find the defendants in the case. And there was like hugging and crying. And they told us that the whole jury wanted to acquit them on everything, but thought that they would have to explain their rationale to the judge. You don't have to. You can just vote to acquit. So again, you always have the option of finding a defendant not guilty, even if you believe a law was broken, even if the judge says you must convict. All right, next slide. All right, so these are some of the reasons you may vote not guilty. I'm not going to read through these. You can go get the slides. You also don't have to be able to justify, as I just said, with any particular reason. Let's not be capricious, but you don't have to be able to point to one of these things. It might feel like it's good in the jury room when you're deliberating to know which of these things might be good arguments to your fellow jurors. All right, next slide. All right, so tips on not getting removed. If you openly say you plan to ignore the law or instructions, the judge can dismiss you, like during the trial. If you discuss intentions of jury nullification with others before deliberation, it can be misconduct and even jury tampering. And like, there's no reason to do that. Because if you actually can't have a reasoned discussion with the other jurors about why, why you're going to refuse to convict, then yeah, just like don't have that discussion. You don't have to say, I'm here to nullify. I don't think we are here to nullify. We're here to nullify if we think that's what's just. And if you think it's just, you can come up with a reason why you think it's just to talk to the other jurors about. But again, you don't have to justify it to the judge if you all return a verdict that seems to go against what the judge was expecting. And then during deliberations, people rarely get removed mid-deliberation, but it can happen if you admit to refusing to follow the law. Or just don't say the words during nullification. And then, yeah, let's go on to the next slide. Okay, then what? So afterwards, don't say you did jury nullification. Other people who observe the situation can point out that looks like jury nullification. But and certainly don't discuss it before the case concludes. And afterwards, you don't need to say that's what you did. Let somebody else say that looks like jury nullification to me. And you've added a little more justice into the world, and people can almost never be retried, even if the courts believe that jury nullification occurred. Unless, of course, it's a mistrial with a hung jury, then the prosecutor, because the jury wasn't unanimous, the prosecutor could try the case again. All right, next slide. Okay, so do you want to spread the word? Let's go. You can pass out flyers. You can go to a courthouse. Often jury selection happens on a Monday morning. In some places, jury selection happens right before a particular trial. Some places trials start on Tuesdays, but early before people are placed on juries. Don't be there to target jurors in a particular case. That could be understood as jury tampering. And people have been charged for doing this before, but in the cases we know about, those charges were dismissed as the courts found it lawful to pass out educational flyers outside the court. Next slide. You could also hang those flyers all over the place, right? You could do this training. This slide deck is available, as you've seen several times in the chat, on the Freedom Trainers website. You could lead this training in your home place and help make sure that more people understand jury nullification. Jury nullification is different in civil trials. The judge has more leeway. So a judge can actually issue a judgment that is different from the jury's in a civil trial, or they can order a new trial. So what we've been talking about tonight is primarily about criminal trials. Oh yeah, and some of the details of juries are different from place to place. How much folks get paid. So generally you get some sort of per diem payment for being on a jury. It is very low where I live. The jury size can be different depending on the level of the case or just where you are. It's usually 6 or 12 with a 6-person jury usually has one alternate, and a 12-person jury usually has 2 alternates who have to be there the whole time in case something happens and they need to replace one of the jurors. And whether the verdict has to be unanimous or not, which is, again, something to look up where you are. It's almost always needs to be unanimous for a conviction, but you should look it up just to be sure you know. All right, next slide. All right, this is the Q&A period. And I am going to look at a document where questions have been compiled for me as they come in. Okay. If you were go to court as a juror, would they have to explain the requirements for conviction? Yes. So they're at the end, after both sides do their closing arguments, then usually the jury gets sent away so that both sides can argue with the judge about what the jury instructions should look like. And the jurors aren't allowed to hear that argument. And then the judge decides how to instruct the jury, but it will always say sort of what the legal standard is that needs to be met for conviction. And that's when you'll hear, if the state has met this burden, then you must convict. And you know that you could also use your conscience if you think it would be unjust to convict in this situation, even if you think the case was proven beyond a reasonable doubt. How can you deliberate without explaining you think the law was unjustly applied? I don't know. It seems to me I think in deliberation, you can say, I think the law was unjustly applied. And part of that might be, this is part of the, like with the sandwich guy, like, yeah, sure, he threw the sandwich, but it didn't actually cause any harm. I think that'll be on a case by case basis. And yeah, that's all I'm going to say about that question. That question was here twice. I'm only going to answer it the once. Is it fair to say then that juries refusing to convict for unjust laws can set a broader precedent? The word precedent is specific in a legal setting, so it doesn't set a legal precedent, but it begins to change the culture and can influence other people and help other people to know that you can refuse to convict. And so in a more layperson sense of the word precedent, sure, we can begin to change the culture about what courts are and what the role of the jury is. Is it enough to say I can keep an open mind when it comes to voir dire? Yes, absolutely. I think that's enough. And then if you don't say anything more, you've also hit that mark of not talking too much. It is better during voir dire to keep your responses minimal. In any potential high-profile upcoming trials, how common are jury questionnaires that are filled out before voir dire? You get a packet with your summons. In my experience, you always have to do this, but that might not be true in every place. So whether it's high profile or not. I have been part of a defense team in which you receive sometimes 3 days before, sometimes the day of, a packet. Like the defense attorney will receive a packet, and that's probably when I'm sure that the prosecutor gets it at the same time as the defense, that has all of the answers to the questionnaires from all of the potential jurors in it. And sometimes volunteers might help the defense sort through those to flag any questions that they might want to ask. Or like, for example, a protest trial, there was a state Supreme Court justice in our jury pool. And we thought we weren't really sure that we wanted that. So we were able to flag that for the defense attorney so she could ask that person a particular question. Otherwise, you might have a jury pool of 60 people and an attorney trying to go through that themselves might not see as many details. But in general, you either are going to have to fill out in advance or when you get there the day of. You're going to need to say where you work, some other, like what your education level is. Can you put flyers in court bathrooms? People can do whatever they want to do. I'm not sure it's lawful. So I wouldn't necessarily advise it, and I'm not a lawyer, and people make their own choices about what they're going to do. All right. I think that we're over time a little bit. I want to thank you all for coming to this. There will be another jury nullification training on, it's March something. Sorry that I can't say off the top of my brain when the next one is. All the materials are on the website. Were you going to help me with that?
March 5th.
March 5th.
Yes.
Thank you. And I'm going to close us with a poem because it's how I roll. And this is called, and it'll be in the chat too. It's called An Invitation by Lady Speech. You can find her on Instagram. She asks, you know what? I feel like I was just invited by my country to be my most brilliant and unhinged, my most magic and divine, my most righteous and ratchet, my most grounded and dangerous, my most radical and spiritual, my most soft and sword version of myself that I have ever been. And you know what? I accept. I hope you all accept to go out and use your conscience, do it conscientiously, and I hope to see you in the streets and in the courtrooms and all the other places that matter. Thank you.